there's an attorney I met with recently who's like, yeah, I've lost my last 6 jury trials. I'm like, wow. That's weird. I would think you'd be out of business because that's pretty rough to lose 6 in a row. And then we go on to talk, and this attorney is explaining that, well, but I've settled. I just settled a case for $7 million. I settled a case for $5 million. So I've got money coming in. I'm like, well, that's great. I'm like, why do you think you keep losing the trials? And they've never done a root cause analysis to figure out why. But when we started talking about it, I can tell you what I think a big reason is because he's settling all of his good cases for probably less than he should settle them for, because he now needs the cash flow. And the cases that he should be settling because they've got problems and maybe aren't winnable, he's going to try, and he goes to trial on them. And what happens there is that it does 2 things. One, it reinforces the fear of doing trials. You have to win. Losing over and over and over again it's a paralyzing event. It's very difficult for anybody to lose trials and keep getting up off the mat and going and try the next one. At some point, people give up. The problem is the defendants and the insurance companies know this. They're going to settle the good cases most of the time, not all the time. I mean, look, you see all these huge verdicts that happen. It's because somebody misvalued it. But a lot of times the defense isn't wrong about the value of the case. I sit as an arbitrator, and I just arbitrated a case for a plaintiff and a defendant, and the plaintiff put the case on, and I kind of looked at the case, and at the end of it, I felt the plaintiff caused the wreck. The plaintiff was the one who made an illegal turn. And so I gave a defense verdict, and it's one of those things where people are like, well, you're a plaintiff lawyer. Yeah, I am a plaintiff. I'm a hardcore. I believe in what we do. But believing in what we do comes with a responsibility. We have an obligation to take cases and vet them. We have an obligation to vet. I was talking to Christian earlier this week, and one of the things that stuck out to me is that this year, so far, we have turned down almost 1,200 cases. We've turned down almost 1,200 cases that have been referred to the firm. Many years ago, I was at a crossroads in what the firm was. And this gets back to a really important part of your own firm. You have to define what your firm is. You've got to define that. And what do I mean by that? Well, there's all different kinds of firms. You can be a firm that's going to advertise and do big volume. And then that that's what you are. You're an advertising firm. You're going to have big volume, and you can do. It has been proven. You look at Morgan & Morgan. There's a firm that advertises more than anybody in the world, and they try more cases than any plaintiff firm in the world. That's the exception to the rule. Most advertising firms don't do that. It's very difficult. But understand, just define what you're going to be. If you want to be a litigation firm and an advertising firm, then you need to figure out how that's going to work. And one of the things that, in order for that to work, you have to have a lot of attorneys, and you got to have a lot of good support staff that's going to allow that to happen. We just hired an attorney from another firm who was at an advertising firm, and at that firm, look, basically the way they handled it was, you've got 200 cases in litigation, pick the 5 important ones and have your paralegals do the minimum on the other 195 and get what you can and settle them out. And then on those 5 important cases, really work them up. And that's a tough way, I think, to practice law. I don't think that's fair to any clients. So define what do you want to be? And what we decided, I was at a crossroad where I wanted to be a trial lawyer. And this was about 10 years ago, 10 years ago. I wanted to be a trial lawyer. I'm like, okay, I'm making the decision. I want to be the best trial lawyer I can. Well, at the time, it was just the only attorneys in the office were myself, my partner, Will Sykes, and then Matt Granda, who was young associate at the time. He's now our managing partner. There was the three of us. And I'm like, okay, great. We're going to be real trial lawyers. We're going to try everything. Well, I think we had like 65 cases in litigation. Just do the math on what that means. Okay, there's 20, just say we each had 20 cases in lit each. How are you going to be a real trial lawyer with 20 cases in litigation per attorney?
And Sean, I think you filed them, some of them at the same time.
Oh, I think we filed like 30 of them at once because that was
Yeah,
smart.
the same court calendar.
Yeah, we had, yeah, it was not the best decision. I thought it was going to be awesome because I was going to really show the other side. I think we had 30 cases that all had the same filing date. It was a real aggressive push to being a trial firm. Not the brightest move. And look, what I'm telling you is I've made a whole lot of mistakes as a firm owner. That's one of them. But the issue is if we took 5 depositions per case, just 5, which is, many of your cases you have 15 or 20. I mean, there's just a lot of depots in some cases. But say you average 5 depositions per case, and you got 20 cases. That's 100 depositions. So that's 100 days out of 200 business days a year. And then you got to prep for the depot, and then you got to summarize the depot. You start looking at the math, and it doesn't take long to figure out that's just too many cases. And so I just did the math on this. We have less than 11 cases per attorney in litigation at our firm. And that's because we want to make sure that each case gets properly litigated the way it needs to. So really think about that. I want you to, everybody that's on listening out there, think about that as we start to go through the process that we're talking about. You can do it, and I think it's a best practice, and it's something, if you want to start getting the best results, you should do that. We just had one of our associates just had a case the other day that internally got valued at $150,000 by one of the partners, and I get a text message 2 days ago that the associate attorney settled it for $485,000, and I was like, "What the hell? That's amazing! What happened?" And she spent the time in discovery and really got him over the barrel with some really good, we call them, it's OSIs, other similar incidents. She basically had him. And she did a great job of uncovering a bunch of other similar incidents, getting some really good testimony out there. And so it was really clear they were going to have to pay. And thanks to Geordan Logan, because our firm does a lot of trials, he recently tried a case that involved a similar, not same property, similar slip and fall with the same injury, and got, what was it, 650, 700,000? I don't forget what the verdict was, 685, something.
Yeah, it was like 600, 650 was the verdict.
Yeah, so Jordan gets this verdict that kind of sets the value for a broken kneecap, which was the same injury. And that's what happens is as you start to do these and try more cases, because what happens is also when you have adjusters that are trying to tell you the value of your cases, they're like, well, we did a verdict research. No. I don't care what other firms have done. Why don't you look at our verdicts and compare? This is how we value them, is because this is what we get. And that's what you want to start to do. And so, and the other thing is work within your communities. We have a listserv here in Nevada called Justice Through Verdicts. And it's an awesome listserv and I am really proud. I mean, the attorneys the trial lawyers we have in Las Vegas are badasses. We had, before pre-COVID, we were doing a trial in October of last year, so about a year ago, and there were 5 of my colleagues on the 2 floors above and below us doing plaintiff personal injury trials. And I'm like, man, that's pretty cool. There's 6 of us. There were 6 total trials. 6 plaintiff verdicts came out in the course of like 5 days. But we made a concerted effort within our community to get together, share information. And we're going to talk about this as part of the investigation, but share information, and then really encouraging each other to go to trial, and then having monthly meetings, which have kind of tapered off during COVID, but pre-COVID, every month we'd get together and we'd have attorneys go through and debrief either a win or a loss. And nobody gets shamed for losing a case. I think that's really important for people on this call to understand. Everybody loses trials. If you're going to be a trial lawyer, you're going to lose, and it's okay. You hold your head high, because the courage to go to trial, there's so few people to have that courage. And I have mad respect for anybody that has the courage to go to trial. And you learn from it, and you learn, again, this is part of doing the root cause analysis. You need to understand why you won, but more importantly, when you lose. And for any of, it's been a few years, but I had a run where I had some really big verdicts and back-to-back verdicts in 2016. And I thought I was walking on water. I couldn't lose. And then we had a case, it was a med mal case. And we had done the focus groups, and we knew we couldn't win. We knew we couldn't win at trial, but we had made an agreement with the referring attorney who had referred us 3 cases. This was the 3rd of the 3. We'd done really well in the first 2. And so we agreed, well, a handshake deal is a handshake deal. We're going to go do the trial. We talked to the client. We had the client sign off on the fact that she had a 0% chance, in our opinion, of winning. We start the trial, and we had the greatest judge ever for this particular case. He gave us every ruling you could ever get in your favor to win a case. He gave us everything. There's no way we were going to hold the verdict on appeal, because he made a lot of rulings that probably would have got reversed. And we got defensed within, the jury poured us out within like 30 minutes. And it hit me, like, even though I knew logically I couldn't win, I believed I still had a chance. And then what was heart-wrenching is I got called in to do another trial by an attorney, and literally just came in a couple days before trial to go try a case in another jurisdiction. And it was a products case, and they did not sue the manufacturer of the product. And I thought I could still win the case, and I didn't. But I was not so arrogant that I didn't share these losses with our group. And sharing those losses and why you lost and looking at it really helps. And it helped people understand what happens when experts say certain things, or, this goes that way, or whatever. It's really an important thing to understand and to work together. So I wanted to talk about the idea of being selective in the cases you take, and selective on what cases you settle versus the ones you try. Because when you have that case that's great, and we all dream about these cases, I can't tell you how many times I've seen attorneys settle that dream case. I just had an attorney that I was speaking to recently that was telling me about this case they settled for mid 7 figures. It was a solid. I was like, oh man, I didn't know anything about the case. I'm like, they're telling me they settled the case for $7 million. I'm like, holy shit, that's a lot of money. And then they told me the case, and I'm like, oh my God, I wouldn't have settled that case for less than $25 million. And so a $7 million settlement may or may not be good. $7 million settlement could be a disaster. But the problem is that that's not the case that you should settle necessarily. Obviously the client dictates. I'm not telling you to run roughshod over your client's desires, but there's cases that you should try, and there's cases that you should settle. And I'll give you an example. I'll give you 2 examples. We had a premise case against a hotel here. And Justin, Justin just had a comment here. He wants to know, can we discuss how we go about turning down a case in a way that preserves the relationship so the person may call back if they have another matter? Yeah, let me talk about that, because I think that's important. Obviously, for our firm, a lot of the cases that we turn down come from lawyers. We turn them down for a variety of reasons. Sometimes we turn them down because it's too close to the statute of limitations. Sometimes we turn it down because the damages just don't seem like they're there and it doesn't justify the time that it's going to take to get the recovery. Sometimes we turn it down because I don't like the venue. Sometimes I don't want to go there right now. I've turned down some cases in Mississippi and I just don't want to go to Mississippi right now. I've enjoyed litigating all throughout the South, but I'm trying not to go to Mississippi. Nothing against, if you're from Mississippi, nothing against you. It's just a rough place to practice. But we have a great example right now. We have this young attorney in Las Vegas that's referred us. How many times is he, the tow truck case that we just took?
Oh yeah, we're going to sign up 4 or 5. He's to work with us on. So
he's referred us 4 or 5. The way that we do it is we run a lot of focus groups. So even if we're not, if we're on the fence about a case and an attorney's referring a case to us, we're going to run a focus group. So at a bare minimum, the attorney's going to get a free focus group out of us looking at the case, which isn't bad. But we always, and then we help. I mean, one of the things that is important, especially if you're talking about working with attorneys, is help them. We help attorneys all the time and answer their questions and give them documents like we're going to do today. We give forms away and give briefs and help with anything they have, because even if we're not going to take the case, we know that if that case does well, it helps us indirectly because the value of the cases in the community are valued more.
And Sean, if it's a referring attorney, they're getting a telephone call from either myself, and we're communicating exactly that, right? It's, look, these are the red flags in the case. This is why we can't take it. Or, hey, look, these facts, we're going to roundtable this. We're going to focus group this case. We're going to give you the red flags from a focus group. And the case that we're taking with this other attorney who's tried to refer several cases with us, we walk through the good and the bad with it. But we have that personal telephone call with them. And sometimes if it's a referral through Sean or Will or such, all of us are on the telephone call. If it's not through a referral through an attorney, we make sure our clients are getting everyone who calls in is getting a telephone call, everyone. And they get a telephone call that is a rejection. And they will also get an email. It's a cover your ass type of thing too, but they will get an email and a text message from us. So every single person who communicates with us, and we get a lot of medical malpractice calls, right? Because that's what we practice. And those people have been rejected maybe 4 or 5 times before they call us. And they just want someone that is listening. And sometimes that matters the most. And they're going to call us back just by the way we treated them. But every single person gets a telephone call. If it's a referring attorney, they're going to more likely than not via email or telephone call. They're going to speak to myself or Sean, but we're having an attorney talk to them about those matters.
Yeah, and I think that's the big thing is having attorneys talk to people. A lot of times, prospective clients, that's all they want is to have somebody listen to them, even if it's for 10 minutes. And it makes a difference. And you got to have the system set up where you have the time. One of the big issues is just not having enough time. And it's one of the things that I love about my job is that I have time. I have time to teach. Because all I do is trials. And so right now, because trials are kind of at a lull, obviously, I've been teaching. I've been doing a lot of research. I'm working. I'm putting together a new class at the law school. So I mean, there's things to do like that. Cody Lyons has, let me see what Cody's is. Justin, I hope that answered what you were asking for. But mainly it's just when you treat people with respect, they're going to call you back. I think that's important. Let's see. Cody says, as a new firm owner, if this isn't too off topic, can you all talk a minute about how to get these big cases? My referral sources are almost exclusively interpersonal, and no one is giving away their $25 million cases or just about getting good referrals. Cody, I got a great story for this because I've had my own firm since 2005. I didn't have $1 million case until 2012. 7 years. Now, is that right? Is that really true? Did I really not have $1 million case? Or did I just not know that I had $1 million case? The reality is I didn't know that I had $1 million cases, because I look back at a lot of the cases that I settled for less than $1 million. And if we were to get those same cases today, there's no question in my mind that we're settling them for way more than $1 million. And so, getting the big cases. Now, one of the weird things that I can tell you is that I spent years and years and years trying to get big cases. And then I started getting big verdicts. And a weird thing happened. People started referring their big cases to me because they know that we can handle big cases. And it's kind of one of those self-fulfilling prophecies. The reality, though, is that $1 million is not that much anymore. When you think about what $1 million case is. And I say that not from the standpoint that $1 million isn't actually a ton of money, because it is. I'm talking about the cost of medical care in this country. I'm talking about the way that American citizens view $1 million. I mean, this morning we're hearing about $908 billion bailout. The last one was trillions of dollars. And now you're talking about $1 million. And so the likelihood of jurors giving larger $1 million, multi-million-dollar verdicts is much higher, just because the vernacular of our country has made it clear that that's not a lot of money. But the biggest thing is the cases you have, work them up. I think that the cases you have may be $1 million cases. You got to do the investigation. And this is going to get into what we're going to talk about today, about this concept of how do you make a premise case big. And let me tell you something. I work with some really awesome referring attorneys that every single time they refer me a case, they've undervalued it by millions and millions of dollars. We had a case recently that was a slip and fall case that the referring attorney was working it up. He had determined that this was a hip injury case, and that the value of the case was about $500,000 best day. We got the case, looked at it, read the medical records, actually went back and read every medical record, which is important, and realized, holy shit, that's a brain injury case. And 2.5 years later of us litigating the hell out of the case resolved for just under $7 million. Again, that guy had a case that he thought was a $500,000 case best day. In reality, it was a $7 million case, and he just didn't know it. And so, again, how do you get the big cases? You may already have them. And it's this idea of being better at doing the investigation, better at understanding why is a case worth millions of dollars. And then, and one of the things that may make sense is working with another more experienced attorney. It's one of the things that I wish I would have. I had a great opportunity as a young attorney. I had a great, my first attorney I worked for, he and the partners at the firm were awesome. They were criminal defense guys. I learned a ton. To this day, I still talk to them. And when there's questions about evidence, they're my first phone call. They're great mentors. I had a partner that I subleased space from back 12, 13 years ago. He's still a great mentor and a great resource. You don't necessarily have to split fees with those attorneys. They'll help you. But one of the things that I would tell you that is very valuable, but I caution you at the same time, is working with a more experienced attorney and learning what they're going to do. The danger in that is I had thought I made a great decision about 12 years ago, 11 years ago, to bring in the best trial attorney in Las Vegas. And he's going to teach me how to understand jury questionnaires. And he's going to teach me all about voir dire. And he's going to teach me. I wanted to learn. I was so desperate to learn because I didn't know. And I bring him in this case, and long and short of it, the case settled for like $7 million. This case was starting Monday, settled Sunday night, the day before trial, before we were going to pick a jury. So we have the whole week where we're supposed to be picking a jury. So I said to the referring attorney, I'm like, can you come over to my office or I can come to yours, and can we sit down and go through all the jury questionnaires and go through the voir dire you're going to run and teach me? And his response was, no, I'm busy. I'm like, what the hell do you mean you're busy? We're supposed to be in trial. I mean, you've been in the case for 4 weeks and made $1.4 million. I mean, I think you can make time for me, right? I mean, Jesus. To me, that was like, at the time, that was more money than I've ever made ever by a long shot in a case. And I gave you 1.4 million. You can't make time for me. It was so offensive that I told myself I will never be in that position again. And that's what really sparked me on my journey to learn as much as I could so that I could give back and make sure that anybody that works with me, that never happens again. So a big part, if you're going to work with somebody, check them out. Make sure they're not that type of attorney who's not going to share information, because it doesn't, my goal is anytime somebody works with me, my goal is to get them to learn so that they don't need me in the future, so that they can not only do it on their own, but share the knowledge forward with another young attorney and keep this process going, because which is why this case analysis programming is so important to me and why it's so important that it's free, because we have to share information with each other. It's a critical aspect of how we ensure that our clients get the fair results, because we are under attack nonstop from our state legislatures and Supreme Courts that are enforcing, a direct assault on the 7th Amendment and taking away victims' rights all the time with tort reform. We have to help each other. We're all we have. And so make sure that when you're working with attorneys, you do that, and make sure it's an attorney that you're going to learn. But then you've got the obligation to ask questions and to show up. I can't tell you how many times attorneys are like, yeah, I want to learn. I'm like, great. And they just disappear. And the next time they show up is when it's time to get the check. I'm like, it doesn't bother me. If that's all you want, it's fine. Whatever. I can bring the horse to water. I can't make it drink. But so that's something to think about. So I spent a little bit more time than I wanted to on this morning, but this is something that is so important. And it's so important for us all to understand that you have to be more selective with the cases you're taking. Define the type of firm you want to be. My friend Stuart Ratson out of Florida, he's one of the best attorneys I know. He works with Stuart Weissman also. Just these guys are like the best of the best trial lawyers I know. I mean, they really are cream of the crop guys, not just in the work they do, but the people they are. All right. And their firm, I haven't talked to them. I talked to Stu Weissman recently. I don't know if he's watching this morning. I hope he is. But I last talked to them, Stu Weissman, a couple weeks ago via text. But their firm only handles maybe 5 or 10 cases. But they really work hard on those cases, and they're big cases. And so you can make more money with less cases. In fact, almost every firm I know that's successful takes less cases. And they keep room for those big cases when they come in so they can do better for the client. And so think about that. Less is more. If you want to be an advertiser and that's your model, that's okay too. There's nothing wrong with that. Very successful law firms can do that. And some of the best trial lawyers I know, I mean, gosh, Keith Mitnick is anybody going to doubt that Keith Mitnick is not one of the greatest living trial lawyers? Of course he is. The guy is amazing. If you guys haven't seen his brush strokes, I think he's up to 25 now. I'm sure it's going to end up being a new book. Keith Mitnick has the best. He's just the best. I love what he writes. I mean, the guy is so brilliant. And he works for Morgan & Morgan, which is the biggest advertiser in the world. I just literally got this, and I was like, look, who's the biggest advertiser in the world? Not even close, Morgan & Morgan. And they're the biggest by a long shot. And they've been able to do something that's really hard, but it can be done. But what I can tell you, if you're going to be an advertising firm that doesn't try cases, you're hurting everybody. because you're going to end up taking cases and driving the value right down into the gutter for everybody else.